Morning, everybody. My name is Glenn Silloway. I'm with the League of Women Voters, San Luis Obispo County, the Social Policy Director, for whatever that's worth. Today, we're going to enjoy the presentation of Ashley Raveche, who is the volunteers her precious time as the Deputy Director of Social Policy for the League of Women Voters of California. Before we get started, I do want to say that we are going to have Q&A open. Chat is off. If you want to communicate something with us, go through the Q&A. And at the end of her talk, Ashley will be hanging around to answer your questions. I'll probably read them for her and then we'll go from that. So one more thing. On May 2nd, there's going to be a lunch with the League at noon on Monday, May 2nd. It's going to be talking about the redistricting issues here in this county. People are confused because the changes the board of supervisors made are going to be taking some of us out of voting. I don't get to vote this year. Other people will get to vote twice. It's going to be kind of weird in these new districts. And Julie Roderwall will be on to explain how it's going to affect everybody. So if you have questions about your own status, join us for Lunch with the League Monday, May 2nd. All right. Ashley participates in collaborative policymaking for local and state groups with a focus on public safety, open government, and human rights issues. She is a past president of the League of Women Voters of San Francisco and volunteers now, as I said, as the Deputy Director of Social Policy for the League of Women Voters California. She advocates for more equitable, just, and bias-free policies in the criminal justice system. And she is very active in the Criminal Justice Committee at the state level. So she's quite knowledgeable about these issues we're talking about today. Since 2018, she has served as a stakeholder for the San Francisco Police Department's Executive Sponsor Working Group on Use of Force and the Executive Sponsor Working Group on Bias. During her presidency of the San Francisco League, the League of Women Voters in San Francisco was awarded the Hero Award by the mayor. She recently was honored with the Emerging Public Leader for the United Nations Agenda 2030 Award. It's a long name for an award, for her advocacy in human rights and racial justice. She is a Bay Area native and is raising her two daughters in Marin County. So Ashley, take it off. Take it.
Thank you, Glenn. I appreciate you inviting me to provide this overview to League members and to League statewide members who are spending their lunch hour with us. So my name is Ashley Raveche. I go in the She series. I am the volunteer Deputy Area Director of Social Policy for the League of Women Voters, as you mentioned. And I'm a policymaker, not a practitioner. So if there is a question that comes up in this webinar that I'm not able to answer, I will make sure to follow up with the League members via Glenn or other avenues to bring you to the resources that can better answer those questions. So we have a lot to cover today. I'm going to be sharing a very broad overview of the criminal justice reforms that we have achieved in California, specifically highlighting those reforms that League either co-sponsored or we supported, and review where local leagues are actively engaged in compliance and implementation of these laws. So this includes the Racial Justice Act, AB 2542, Use of Force, AB 392, and its companion bill, SB 230, Sheriff Oversight, AB 1185, Racial Identity Profiling Act, AB 953, Officer Decertification, SB 2, and Officer Misconduct, SB 16. My goal in this very short hour is to really highlight what has changed in these laws and expand on the interplay of the access to criminal justice data as a resource for local compliance. So after I've completely overwhelmed you with a deep dive into the law and the policy, I will slow down, because really the takeaway from this webinar is how local leagues can get engaged in criminal justice reform, whether that is sharing resources that we have provided in local toolkits, or really just planting those seeds for implementation if your local league is willing and able to help with the compliance efforts. Again, if you have any questions, please use the Q&A function, and we will have time at the end to address some of those concerns. So league implementation is supported by our positions. And let me just quickly review what that criminal justice position for league is. It's a system that is just, effective, equitable, transparent, and fosters public trust at all stages. We focus on eliminating systemic bias and policing practices that promote safety for both law enforcement and the communities they serve. And this is something that really sets us apart from other advocacy groups. We don't choose sides. We support all aspects of public safety, and we believe that every individual is a stakeholder in this. So the first key takeaway is that local leagues can use these positions to advocate. But you remember, we speak with one voice here. So that one voice is our position. And then if it is a pending bill, which is nothing I will be covering today, we implement that through the state level action. So why is implementation so critical? Well, as we know, changing the law is only halfway up the mountain, and implementation occurs on the other side. You have to be very careful with your footing when you're going down the mountain. It takes trust, it takes relationship building, and it takes collaboration by all stakeholders to adopt the new law as practice. So the first of the justice reforms that I mentioned is the California Racial Justice Act, or AB 2542. It was enacted in 2020, and I'm incredibly proud that the league was a co-sponsor of this effort. It prevents the state from seeking or obtaining a criminal conviction on the basis of race, ethnicity, or national origin. Specifically, you can raise a Racial Justice Act claim with evidence that there was intentional bias directed at the individual by the attorney, by the judge, a jury, juror, law enforcement officer, or expert witness in the courtroom setting. There could be racially coded language used in court, for example. Often officers or prosecutors, we've seen that they are comparing individuals to animals as a way of dehumanizing them and showing their anger and aggression. We also see racial disparities in the charges. We see racial disparities in convictions, and we see racial disparities in sentences. So the goal with the Racial Justice Act is to remove that bias discrimination that was a legal tool in the criminal justice process. So allowing that to persist impacted all decisions from charging, sentencing, and convictions. And so now that this is law, this is something that we are implementing. Now, I won't expect anybody to review this chart. This is just something that we did as a graphic as part of our advocacy on the bill. And this shows you the process of filing a Racial Justice Act claim. The one thing I want to point out is that Racial Justice Act is prospective only. That means an individual can only file a claim of discriminatory disparate treatment based on their race, ethnicity, or national origin while they are in the courtroom setting. So while they are undergoing the trial. And there's various points in the process that they can raise that claim. And that ultimately, if bias has been determined to permeate or to exist at all, then there's some remedies for that individual to remove the racial bias. So moving on, did you know that policies are created by law enforcement departments, oversight bodies, and Lexipol, rather than the peace officers' standards and training? People are often surprised to learn that our state commission posts the peace officer standards and training doesn't mandate, review, or certify policies, only training. And this is something I just wanted to point out before I move on to the next two bills that I like to review in tandem because they are companion efforts. The first is AB 392, use of excessive force. This is a landmark law that elevated the use of deadly force to the highest standard in the nation. And prior to its passage, the United States Supreme Court in Graham v. Connor set that standard. It held that an officer's use of force must be objectively reasonable under what they deem the totality of circumstances known to the officer at that time. In AB 392, under this new law, California elevated the standard for deadly force from reasonable to only when necessary to protect the sanctity of human life. The law further created criminal liability for when officers use deadly force when it was not actually necessary. Now, again, the way they view that is under the totality of circumstances. So our legislator, our courts, our attorney general, and even the peace officer standards and training have adopted this necessary standard. In the law, there were some additional definitions. So the definition of imminent threat limited the likelihood that an officer could claim that there was no need to use deadly force. That there was a need to use deadly force simply to get an individual to follow their commands. So this law removed that as an option. It's only when necessary. It also made clear that officers must use other techniques to resolve the situation without relying on force, such as de-escalation. That is a critical mindset, part of their training, a use of time, distance, and that awareness for de-escalating the situation without having to rely on force. The last thing I want to point out in the change of the law is that it ensured officers are held accountable for their conduct leading up to the shooting or the use of excessive deadly force. This allows decision makers to provide that evidence, whether it's reviewing the policy or reviewing the body cam footage or reviewing what the officer's actions were prior to the deadly force, and looks at whether or not the officer de-escalated that situation. So part of the elevated standard was that SB 230, Peace Officer Standards and Training, was also signed into law. This is a companion bill to AB 392, or the use of deadly force. And what's interesting is that prior to AB 392 or SB 230 becoming law, there were no state mandates that required officers to de-escalate. There were no mandates that required law enforcement departments to even have a use of force policy. There were no mandates to report excessive force by officers or policies on disclosing records of when use of force occurred. And the legislature had not established clear guidelines for discharging of firearms. So what SB 230 did as part of a companion to the elevated force standard is it created those key provisions to support AB 392 reform and enacting minimum guidelines for policies on training specific to law enforcement departments must adopt a use of force policy. And besides that, that policy must be publicly accessible. De-escalation is part of the training and it must be included. There is a duty to intercede in deadly force. There is a duty to report excessive force. And what they've also adopted is a universal proportional force continuum. What that basically means is that an officer is only justified, that reasonable standard, to use a specific type of force depending on the proportional force. So if somebody is fighting back harder, then a little bit more force can be used. But you just don't come in with deadly force when somebody's sitting there and following commands for no reason. Furthermore, data on the use of force and the use of a firearm was also collected. So one of the last bills that I will do the deep dive on is Sheriff Oversight, AB 1185. This is a new law. And this is very much in the vein of League, of looking at citizen oversight, transparency, accountability. And what AB 1185 does is it allows a board of supervisors or the vote of the people to establish a sheriff oversight committee. It can be composed of civilians. It can be composed of civilians and officers. It can have an inspector general at the helm. The law does not provide how the oversight agency should be comprised. It just provides them the opportunity to create one. Moreover, the law provided that the oversight body has subpoena power to compel testimony and documents pertaining to those duties under the office of the sheriff. And this is a very big one because our sheriffs are elected officials. And often they respond that their only accountability is on the vote of the people to elect them out. 1185 is changing that. It is allowing for bodies and to be compiled so that oversight and transparency and accountability can be part of that public safety discourse. So let me review what the duties of the office of the sheriff are, because sometimes people aren't quite aware of all the things that a sheriff's office is responsible for. So first, they are elected officers, and those duties are enshrined in our California Constitution, which is to preserve the peace. They are authorized to sponsor, to supervise, or to participate in any project of crime prevention, rehabilitation, or suppression of delinquency. They are also in charge of serving court orders or notice to appear. They oversee the jails and may often in certain counties act as the coroner, which is the individual responsible for determining the cause of death. And lastly, they have the ability to designate local community members as deputies for law enforcement. And this is interesting because those sheriff's deputies are not necessarily required to do the full training that a peace officer standard and training academy module would provide. So this is an instance if, back in the gold rush days where you had to do gold claim stakes and the sheriff was the chief officer for law enforcement and they had to compile a bunch of able-bodied men to come and help for a specific reason. So that is where some of those outdated duties are prescribed. Now I want to move on to some of the other laws. I gave a long list here. I know you were told that we were only going to review 3, but the next 3 are specific to the data-driven decision-making. And the league position on that is that we support a reliance on evidence-based research in decision-making about law enforcement programs and their policies, which includes scheduled periodic audits of the programs and the policy effectiveness. What's interesting about the data-driven decision models is that the next 3 bills I'm going to refer to are some changes. It's how we've been collecting that data in order to give our policymakers more tools to understand if, in fact, the laws need to take place, or give advocates tools to say, hey, this is what the data says. You need to change how you are engaging community members. It's not using gut. It's not using rhetoric. It's using actual data on what is occurring as far as public safety is concerned, so that when you approach an agency, you have actual facts that can be relied on, and it's incredibly important. So the first one I want to highlight is the Racial and Identity Profiling Act, or AB 953. We are in the final tier of this implementation of the law. So by April 1st of 2023, the smallest of the law enforcement agencies will be required to report data to the Department of Justice. That is an agency with 1 to 334 officers that are employed. That is most of our community in California. We have a large city law enforcement agencies that have been in compliance with the RIPA collection for several years now, but this is the final implementation and of that data collection. So what is that data? That data includes demographic data on stops. It includes the reason for the stop. It includes the result of the stop, whether the individual was given a citation or they were arrested. It includes if there was a search conducted, and if contraband was actually found in that search. So there are a number of other pieces of data that are collected. I will not go through the laundry list, but those are the major highlights. And then this stop data is mandated to be reported to the Department of Justice every single year. And what's wonderful about this law is that the DOJ takes that data and makes it publicly available in their open justice portal. So there's a website link at the bottom. It's openjustice.doj.ca.gov. If you haven't had an opportunity to look at this, I highly recommend it. The next data bill that just was signed into law is the Officer Decertification, or SB2. Officer decertification established a statewide process to automatically decertify officers who were fired for specified misconduct, such as excessive force, sexual misconduct, and/or dishonesty. It provided the Commission on the Peace Officer Standards and Training the power to independently investigate these allegations and to make the decision of decertifying the officer or disciplining the officer, such as a suspension. And moreover, it provided that when in the event an officer quit prior to the completion of an investigation, that the post board would be required to complete the investigation and to make a determination as to the suitability or fitness of that individual to continue to be an officer under California. It also required that sustained misconduct is reported. So in any instance that a local agency has undergone an investigation, anytime those misconduct allegations were sustained, that information needed to be reported and a record kept. What's interesting is that as much as we like to think California is leading these reforms, we were actually responding. Prior to its passage, California was one of 4 states that had no process to decertify officers. So this occurred just last year, and it's something that we are waiting to see the post board create some of these processes, and it will be something that we will keep an eye on and monitor as it unfolds. The last of the data bills is the Officer Misconduct Records, or SB 16. Records of officer complaints are considered personnel files. Therefore, they are protected from public access. Officer Misconduct Records, or SB 16, changed. They carved out exceptions for sustained filings of use of force, sexual misconduct, dishonesty, false arrest, and/or discrimination. Meaning that if there is a file or a complaint and it is sustained on those 5 categories, it becomes a public record. It is not something hidden in the personnel file requiring only discovery if a civil or criminal litigation is filed. It is now the public record. Any individual can file and request these documents and get the information. It further required that a 5-year retention of misconduct records be kept by the local agency. And it further expanded the statute of limitations for discovery of these files. So in the event that there was a complaint filed and an individual pursued either civil or criminal charges, then that record would be kept and part of the court proceedings. And so these were some big changes. I wanted to point out, not to confuse anybody, but there are some nuances that we are still needing the legislature to address, which was specifically a decision in Copley Press, which prohibited oversight agencies, such as the one that we are hoping to create in counties for sheriff oversight, from providing those records as public access. So, for instance, in the district attorney's office or in the agency itself, SB 16 would apply, and you could make that request. In terms of the oversight agency, it's a much bigger obstacle to figure out what they will provide as a public record. The last of the data is a report that the Department of Justice created, 21st Century Policing. And it's 3 sections, very large, deep dive into policing reform and criminal justice. But I wanted to flag 2 of the recommendations just to help support the work that the League is doing in implementing sheriff oversight and use of force constitutional policing reform. Specifically, recommendation 2.2 is that law enforcement agencies should have comprehensive policies on the use of force, including training, investigations, prosecution, data collection, and information sharing. These policies must be clear, concise, and openly available for public inspection. So we have made some leaps and bounds on that. The policies should also mandate external and independent criminal investigations in cases of police use of force that result in death, officer-involved shootings that result in injury or death, or in custody death. So let me highlight that. Just take a step back. That is asking for external and independent criminal investigations. That is different than an agency investigating use of force, officer-involved shootings, or in custody death on their own. In essence, that's asking for external citizen oversight. The last of the recommendations is 2.8, that some form of civilian oversight of law enforcement is important, and that in order to strengthen the trust within the community, this is why it is so important. Because every community should define the appropriate form of the structure of civilian oversight to meet the needs. That is the importance of bringing all the stakeholders together in these aspects. So now that I've gone through a very large scope of the criminal justice reforms that we have seen in California, I'm going to highlight some tools and some resources that the League has created or can connect you to help make this a reality. For local leagues that do not have criminal justice committees or who are looking just to get involved in advocacy, I recommend that League stays in its lane, meaning that we first look at criminal justice reform in ways that we understand, such as voting rights and election education. And the League has done just that. We have a toolkit. Let me vote, ca.org/toolkit, Let Me Vote campaign. It's a partnership that the League of Women Voters of California and the ACLU created. This tool guide for voting in California jails. So this is everything from registering to providing information. And this has come out of the constitutional amendment that the League supported, which allows the restoration of voting rights for those who are formerly incarcerated felons. And this is something that mirrors that voting eligibility at the federal level. So once an individual is on probation or has finished their sentence, they are now eligible to re-register as a voter. And this is incredibly important to restore and get our individual community members re-entered successfully into society. And this is the tenet of the League of Women Voters. The second toolkit I want to flag is the Elect Justice California. That can be found at electjusticeca.org. And this is a toolkit that was designed to educate and empower California voters to decide on their local candidates. Who are the stakeholders? They are the candidates that have the power to directly impact criminal justice decision-making discretion in your county. Everyone from the district attorney to the sheriff. Some counties have elected public defenders. It just depends. This toolkit helps provide that information, what the roles and the responsibilities of the offices are, and some various questions that you could use to help in a candidate forum. Lastly, the League of Women Voters of California through the Criminal Justice Committee has a toolkit. You can, best way, the link is down below. The best way is to search LWVC Criminal Justice Toolkit. It'll pop right up for you. And what this does is it shows everything from our position and our position papers and background to the various ways that we are implementing that position for the various laws that we just reviewed. So now let me go into the local action, because really this is the important aspect of this webinar, reminding everyone that we speak with one voice, that local league action relies on our positions, and that action can only take place if your board has agreed. So one reason to start with the voting and the election information is to get your board more familiar with criminal justice issues, so that if you do decide to start implementing or asking for compliance on some of these laws, that you have a better understanding of how to do that and who the stakeholders are. So the first thing I recommend is establishing an observer corps. So this helps league members learn what decisions are being made, who those decision makers are. It builds community stakeholders. It expands community partnerships. And those are very critical things as part of the infrastructure before you do advocacy in criminal justice. The league does not work alone in this space. This is something that is really important to stress. We work as a bridge between the policymakers and the community members to help create that safe space for open civil discourse and to push reform in a transparent and accountable way. So some of those questions that you can be asking yourself when you're doing your observer corps is observing those power dynamics. Who has that power to shape these reforms? Is it a board of supervisors? Is it a council? Is it the police unions? Who are the stakeholders? And remember that when you start to engage, that you invite every stakeholder. It is important to hear all perspectives before you decide how to act. Who's responsible for the oversight? Is there even any oversight? And how are individuals currently being held accountable? Lastly, it's league. So is this process transparent? Is this information easily accessible? These are pretty simple starts on that observer corps space that you can create, learn, and then be more comfortable. The next thing I would stress is that you build your coalitions and your community partnerships. Because again, the league does not advocate in the criminal justice space alone. We work specifically with advocacy groups that have been doing this longer than we have, that are more in tune with the community than we are, and that help connect us to impacted individuals. League is very good with the stakeholders and the policymakers. And so together, we help bridge those gaps. And here's some examples of some stakeholders you could consider. Ella Baker Center, Initiate Justice. We worked with them for restoring voting rights. ACLU, we have Next Gen. We worked with them to create that election guide for your criminal justice candidates. We have the First Amendment Coalition, because if you're filing a PRA, you're probably going to need their help. You got Open Justice, which is the Department of Justice. The National Association for Civilian Oversight, they are the point of contact for anything that is oversight of law enforcement. And then I like to put this in, NAMI, the National Alliance on Mental Illness. Not only do they help provide often a perspective of those who are most impacted by use of force, which is a third of individuals are suffering from behavior or mental health, or looking at it from the perspective of our first responders, that they themselves are suffering, and we all need to allow the space to heal and to come together and to move. So in a quick essence of a time check, because I do want to leave some time for questions, I want to just highlight where we have been implementing AB 392, which is excessive use of force. So I'm very proud to say that local leagues across the state have helped to achieve some of the only compliance on 392. You can see Sacramento, Oakland, San Francisco, Pasadena, Monrovia, Los Angeles, Long Beach, and Santa Ana. So out of 450 law enforcement agencies in the state, only 8 are in compliance. And when I say in compliance, that is the clearly elevated use of force, use of deadly force to only when necessary. That is clear as day, part of their policy. We see 95% of law enforcement agencies that have failed to achieve this standard are relying on Lexipol. And Lexipol is not meeting clearly that definition of what the legislative intent of 392 is. This is the seed that I'm planting on a potential advocacy that your local league could undertake. So I would like to say that the league has signed on in a coalition support letter to help move Lexipol's policies to become compliant. There's an article by USA Today that you can search for. It's this company's permissive policies are behind high-profile police shootings of Black men in the US. I would also flag that this is in the courts. There are 3 separate lawsuits that are raising the compliance issue. One specifically over Lexipol policies. 2 more were the first tests of AB 392, in which they are moving. One is moving forward in, let me see, Alameda is moving forward. That is where the DA filed the first criminal charges after the law took effect. The second is a San Diego lawsuit where the officer was held liable for use of excessive force. So we are seeing some changes in the law at the level of the courts. Second map. This is the map showing leagues' involvement in AB 1185, which is sheriff oversight. Now, prior to the law, there were already 25 enforcement agencies across the state that had some sort of oversight body. Now that the law has taken effect, league members in Sacramento, King, San Diego, Orange, Marin, and Alameda are actively engaged in establishing a version or beefing up the version they had of their sheriff oversight. This is an incredibly important thing for league to lean into. And mostly I would suggest that our ability to understand bringing all stakeholders together, our ability to understand the value of oversight and transparency, not being a harmful or threatening thing for anyone to have, can help temper some of the friction that we are seeing. It's a scary word for many law enforcement agencies, but really it's a necessary part of the community trust building that is ultimately at the root of our criminal justice position. And the last thing that I want to point out is that the league is still co-sponsoring the California Racial Justice Act for All. Now, in this instance, this is a state bill that we are actively running. If you, as a league member or your local league is interested in getting involved, you need to contact our staff, state staff, and work through those channels. Do not advocate on behalf of this state level effort unless we have provided the green light for that. Local leagues can only act on existing laws, which I have highlighted. But This is taking the Racial Justice Act and expanding equal access for all. So with that, I want to leave some time for questions. Hopefully I left enough time. And I thank you very much. I'll stop screen sharing.
There. Thank you, Ashley. That was a lot of information. I hope we are recording this, so hopefully we'll be able to go through those slides and pick out some good information. There's a couple questions here about AB 1185. I think you may have covered them, but how does AB 1185 change the authorities that the county already had for oversight? They could choose to do it or not.
That's a good question. It really depended on whether you were a charter county or not. It had some legal nuances with that. Ultimately, before 1185, a county board of supervisors was in fact the oversight body, and they could create inspector generals, or they could create oversight agencies, task forces to look into the office of the sheriff. That was always part of what they were allowed to do. What AB 1185 clarified was two important things. It clarified subpoena power, and it further clarified that the board themselves could task a citizen body with the oversight duties and looking into the sheriff. So specifically, there were sheriff's offices that bodies were created by boards. I'll give you an example. Sacramento, they had an oversight agency. The sheriff would not provide them access to information. Public records requests were denied, and they locked the doors and wouldn't allow even the board of supervisors to come in and do that oversight function. So it helps expand and really clarifies for everybody involved that this is the law. It's not actually something to be afraid of. This is really good, and I support it fully.
Okay, thank you. Just for your background information, our sheriff does not have an opponent this year, so we're not going to have an election, for whatever that's worth. Here's a couple more. I think I heard you say that Lexipol does not comply with AB 392. Could you speak a little further about that?
Yes. So in Lexipol's opinion, they have altered their use of force policy to comply. In reading the policy that's provided to agencies, it is very clear that the use of deadly force is not standalone, spelled out clearly that it is only to preserve the sanctity of human life. It is a last resort step. Instead, the current Lexipol policy frames use of force, specifically use of deadly force, in the terms of the case law, which was what I highlighted in Connor, the objectively reasonable and the totality of circumstances, which still applies for the use of force continuum. It's just not the standard for deadly force. AB 392 elevated that standard in that specific realm. And I would like to see Lexipol really provide the clear directives to our officers rather than framing it in terms of case law that doesn't apply or making it confusing, because what post is training, what the courts are looking as far as the definitions and how to look at the criminality of specific instances also raises to necessary. So we just need everybody on the same level playing field. And it's difficult because Lexipol is proprietary. It's not based in California. It's a one-stop shop policy maker, and it writes policy nationally. So they had to go in and adjust their use of force policy specific for California. And unfortunately, my opinion, it's missing the mark.
Thank you. Yeah. There's more on the sheriff here. First, a thank you. That was a wealth of information. And does a nonprofit need to partner with their local League of Women Voters to create an oversight committee?
Does a nonprofit, I'm trying to understand a little bit about that. So anybody could help push that forward through their board. So unless they're going and they're writing a ballot initiative and asking the voters to take up an oversight body, and in that sense, they would spell out exactly how they're going to construct that. They would need to work with their local board of supervisors. And to be effective in that area, I would recommend gathering as many stakeholders, league members, local nonprofits, absolutely everybody, impacted individuals, looking at that RIPA data and seeing if things have been flagged, if many counties under the Department of Justice have been reviewed. We are seeing across our state deaths in our jails that are being reported as not raised to the level of liability, but that's not what the Department of Justice is saying. So depending on your county, you should look into that. And if your sheriff, who's in charge of the jails and in charge of the individuals in jail, has a death that's either unreported or a medical need that went unanswered, they have a constitutional requirement to provide medical care to an individual incarcerated. And if they're not doing that, then that raises a lot of red flags and questions. And then if their office is in charge of writing what the cause of death is, it's really kind of hard to tease out where the error went or whose fault it was. And so that's an issue where oversight would make sense. A third party review of what happened is really the only way to get to the bottom of this.
Yeah. Hard to do, though.
Incredibly hard to do.
Yeah.
And I would flag again that building those relationships of the stakeholders and that trust building, that takes time. The word oversight is a scary word for law enforcement. And so trying to come at it from a place of what League does well. We're not forcing you into something. We want to hear what you have to say, and we are collaborating. It's a collaborative change. But really, we're looking for public safety policy and these agencies to have that trust. We need to rely on each other to move through these very challenging and difficult situations.
Yeah. As one of my colleagues says, we have to really understand what we're talking about before we start recommending changes. So,
exactly.
Yeah. So here's a question. Is the League working on noting that a county sheriff is not an independent investigative body in its relationship with local PD's use of deadly force?
Oh, that's an interesting question. So one thing that AB 392 did under the excessive force was that it created that criminal liability for excessive force or for deadly force. And that criminal liability is a discretion that the district attorney gets to make. Now, there are other laws that I didn't highlight, but they have taken the next step forward, that if there was a deadly shooting or a death that occurred by an officer and that individual was unarmed, that circumvents the local district attorney altogether. It goes straight to the Department of Justice for investigation and review to see what went wrong in those specific narrow circumstances. So in terms of a sheriff investigating, each county has kind of created its own model. Because it's an active criminal investigation, the DA would be able to bring somebody on scene. But that's a relationship, an understanding between those various levels of law enforcement. If a sheriff is called in to do an investigation, that wouldn't be necessarily a criminal investigation into their own, but in some rural communities, they might be the point of contact for the investigation. Therein lies that gray area of who that oversight and that accountability is, leaning on and falling to. Where we will see things unfold. It will all be decided at the court level, but certain communities are going to need to change to ensure that third-party investigations are handled and they're not investigating their own when it comes to the use of deadly force.
So I'm not quite sure I've got um, Gil's question right here, but what it triggers in my mind is curiosity to know how extensive the sheriff's duties are. You listed a number of duties, and what I wondered is, do they apply across jurisdictional boundaries, especially in incorporated areas? What does the law establish a way for the sheriff to intervene in incorporated areas, regardless of anything a local jurisdiction might want to do?
That's interesting. What I've seen for my experience, I live in an unincorporated area. So my law enforcement agent is the sheriff's department.
Mhm.
What we see often is that local jurisdictions or municipalities, the cities will invite the sheriff's deputies to enforce laws. So those are all agreements. In theory, those agreements should be publicly available. So if you have a question about who's really tasked and designated with that oversight of law enforcement. What we find is in my local city, it's actually the sheriffs that are responding, the sheriff's deputies. So one thing that the RIPA data just recently is under review for changing is flagging that exact piece of information in the stop data is, this stop occurred at this location and this agency is reporting it, but really was it contracted out by a sheriff's officer? So you can really understand if you see the data results and you see maybe excessive stops for individuals who are Black or brown, and they're not finding any underlying criminal behavior or activity, it begs the question, why were they stopped? And then the second question of who was the agency doing the stop? Because California law says that that type of racial profiling is in fact discriminatory and illegal. And if an officer stops an individual and gets flagged with discriminatory charging behavior, those charges will be dropped. And if they weren't dropped under RIPA, they will certainly be raised under the Racial Justice Act, that the charge itself was discriminatory.
Okay. Let's see. How do you approach law enforcement without making them suspicious or hostile? I think you've been talking about that a little bit.
So that's definitely part of the trust building. And what I would say is that the recommendation I have is that league members should do a buddy system. We don't go into any of these scenarios by ourselves. It's a lot easier when you're on Zoom, but when you're back in an in-person setting, always have a buddy, just like law enforcement always has a partner. Um, and then to really just be honest, creating those observer cores, which remember, league observers do not advocate. So when you're there in that space, you're writing notes, you're reporting back to your local board or your local committee, you're providing that information so that the advocacy arm could take that and then choose to act. But the observers are neutral parties. They're not there to push or ask questions, or unless they're clarifying questions one way or the other. They're not advocating. And so that one helps create the separation between the observer arm of the league and the advocacy arm of the league. But then, like I said, it takes time. And for me, I've been in a number of different situations with local law enforcement. I firmly believe in the collaborative reform policymaking. I write policy for fire. I've engaged with my district attorney. I've worked with local law enforcement. And I see them as folks that, like all of us, do not like change. So when you start to relate with individuals and you break down some of these boundaries and these barriers, and you see them for who they are, and you see that they're operating under a system of policymaking that is no different than a lot of other industries and spaces. How do you navigate? How do you have those conversations? Bearing through the uncomfortable feelings on both sides takes time and practice. So I don't ever want to tell league to completely detach from that space. The buddy system helps because it wears on you. It is hard. It is hard to hear the impacted stories from individuals. It is hard to hear law enforcement explain that they're doing their best. And until these laws changed, they in fact were enforcing the law. And that awareness helps me be a better advocate, really truly understanding that we are asking them recently to change some of the tools and behaviors, but we're not necessarily looking at them as individuals and humans that are going through that change. We want it to happen like this, but it's a process. And our position provides for the mental health training, the awareness, and the support that our law enforcement needs to be better at their job. And we want to provide those community tools and the community support on the other end to help bring them along. But the change does start within. And that paradigm shift is not going to occur unless all the stakeholders have a common goal, and that they can work together. And when you have two sides that are not willing to sit down and listen to each other, that should bring you pause. As a league member engaging in these spaces, you have to recognize that maybe you're not advocating. Maybe you're just building a bridge to create that safe space.
Yeah, and it sounds like it's you called it a process, and I got a feeling that that process varies by location. We're going to have to kind of feel your way into it. So I've got one last one that I'm going to ask you, and then we'll be at 1 o'clock. We like to stop. Do any of the recent laws or policies address pursuits?
Pursuits of individual suspects?
I assume a car chase or yes, I assume that's what he means.
So SB 230 codified a couple of those pursuits, being that you could not shoot into a moving vehicle. You can't shoot blindly. You can't use your car to ram into somebody. There are some training modules that sweeping reforms in that respect. The pursuit of an individual who's only a harm to themselves, under AB 392, an officer would not be able to use deadly force to stop that individual if they are only a harm to themselves. The question of pursuit comes when that individual is a harm to others. So if they are on the ledge, you can't push them over the ledge. You call for backup. That is what we hope the training and the laws provide. But in the instance of an individual who's brandishing a weapon, running down the street, that's something that the law enforcement officer would have to use their reasonable standard and objective judgment in that scenario. I can't give an answer that'll be a one size fits all. And that's part of the hardship of what our officers are also facing, is that decisions are made in the moment. And so we need to push that they rely on training. And that we need to push that sanctity of human life, which sadly, until AB 392 was passed, was very rarely seen in any law enforcement policy. So they're tasked with enforcing the law. They're not tasked with saving lives. And therein lies the distinction. As a league member who's advocating for human rights on both sides, I want to make sure our officers are protecting the sanctity of human life, because that's where the trust and the respect comes in.
Wow, thank you. You've given us a lot to think about and a lot of things to do, which is a good thing. You have to think about what to do before you can start. So I'm going to cut out now. I hope that you can share your slides with us.
Absolutely.
And we will be talking again about this. I'll leave with one question that has always been in my mind. The police officer standards and training doesn't set standards. So why is that in their title? I'm not asking you to answer that, but it's always seemed to me that there could be a model of standards at the state level that would be helpful, but that's another story. So Ashley, thank you so much. We appreciate your time here.
Well, thank you, Glenn. I appreciate it. And I know I gave a lot to think about. So if anybody has a question, feel free to outreach. And thank you so much for joining us in your lunch hour.
All right. And I'll say goodbye to everyone. We'll see you May 2nd, lunch with the league about redistricting in this county. It's a big issue. You need to know about it.